Good morning, members. It's time to get started. We have got a quorum already. So this is a meeting of the Subcommittee on Financial Institutions Resolution Protected Arrangement Regulation and Financial Institution Resolution Ordinance Commencement Notice 2017. This is actually our second meeting. So perhaps at this point we should invite the official team to join us. Today we have Ms. James Lau, Under Secretary for Financial Secretary and the Treasury, Ms. Polly Kwok, PAS for FSTB, and from the Hong Kong MA Hong Resolution Office, Mr. Eamon White, Mr. Ben Prance, Senior Manager, Mr. Tang Po Hyung, SFC, and Ms. Joyce Leung, Assistant Counsel, SFC. Thank you for attending our meeting. Turning to our agenda, we already did the cross by cross in the first meeting. But members had some questions about the notice and the regulation, so that's why we have this second meeting. So perhaps I should now ask Mr. James TO to raise his questions, 2 questions, and then I will seek a response from the administration. Mr. TO. As I said last time, my concern is that as a matter of law, not as a matter of administrative promise, let's say we have this mechanism in place, and in the context of deposit protection scheme, I as a client, I will be protected in respect of my accounts in that bank up to a certain limit. And now the Secretary may exercise his powers to transfer the business to a transitional entity, a bridging institution, and which may or may not be a bank or an entity holding a licensed bank, a bank license rather. It may work out, but if fails, i.e. a second failure, and in that transitional period, that entity is not a bank, and it's not covered by the definition of under the deposit protection scheme, then those who are holding onto their savings of $500,000 or $1 million will not be protected by the DPS. Well, you may say I'm worrying too much, but this is a question of financial security and also emotional security to many people in Hong Kong. I'm not asking you to get everything done at this stage, but you must promise that in the future the laws will be amended so as to give protection, legal protection. As a lawyer, I would say that there are 2 possibilities to take things forward. First, you may wish to, or should I say, that you should make it a law, a provision, a rule, that you should say in the law, you don't have the right power to transfer the assets and to a non-bank. You may say that have to be considered in the context of a possible financial crisis. All right, so even if you were to transfer this to a bridging institution, which is not a bank, then you must amend the law in relation to the DPS to the effect that even though that particular institution has never contributed to the DPS or covered by the DPS, then still the DPS will cover those clients of the former bank. So it's either this or the other option, but I do not want to see just an administrative pledge, and that is under the resolution mechanism. You're not going to transfer the relevant assets to a non-bank. Or perhaps you have already got some, you can have some shell companies already, which can be then licensed as banks if need be. So this promise may be broken for very good reasons. It may be an emergency. It may be a crisis. Why do you suddenly decide not to transfer the assets to an institution with a banking license? You may want to save someone else as a matter of urgency, and you may have to the balance, the need to protect that second entity from failure vis-à-vis the interests of bank customers. If you want to reserve this power, then I'm sorry, I will have to. Well, of course, technically, I cannot really vote against this, but I would have to say it for the record. If you promise that this will come in the next round, that would be good enough for me. So I want to make sure that in the second failure, we are not going to see the protection taken away, and you are not going to likely change this administrative pledge. I won't accept a scenario whereby the bridging institution is not covered by the DPS protection. So because at that point the customers should have been compensated already, and I don't think that's the legislative intent. Mr. Lau, would you or your colleagues from Hong Kong MA be responding to the questions? I'll say a few words before I ask my Hong Kong MA colleagues to supplement. As we have explained at the last meeting, and we understand Mr. James TO's concern about the different rounds, different waves of resolution arrangements. This is not the administrative intent, or as Mr. TO puts it, administrative promise or pledge. Last time, we talked about Section 12(1) of the Banking Ordinance. The deposit-taking entities must be AIs, authorized institutions. And in the first paper, we have provided to the subcommittee, only licensed banks are offering the protection under DPS. That's in the Banking Ordinance. Although in the FIRO, we did not copy every protection measures in the Banking Ordinance, but we would comply with the ordinance all the same. But so that's why we are not going to transfer protected deposits from a licensed bank from AI to another institution. That second institution may be a bank under the DPS or a bridging institution. As Mr. To has suggested, we are going to get all these bridging institutions ready, and these institutions will be licensed banks. So for the transfer of protected deposits from a failing bank to this bridging institution, well, the DPS will continue to apply. It's not a matter of administrative intent, and this is a matter of complying with the law. So there's no question of doing something in a crisis that the transfer is to a bridging institution which is not an AI. So there's not going to be any transfer of protected deposits to an unprotected institutions. Chairman, I think my point is technical. That's why I want to have this second meeting of the second committee. Let's look at paper 1155. In view of the section 12(1) of the Banking Ordinance, which provides that the MA will not transfer a deposit-taking business to a BI unless this is an AI because of a restriction under section 12(1) of the BO. The wording is would not. MASRA would not transfer this, or it doesn't say that MASRA cannot, as a matter of complying with the law, transfer blah blah blah. If there is a crisis, an emergency, and then you want to transfer this to a BI without a bank license, maybe that consideration in a matter of in a crisis would prevail over this particular promise. And also under 12(1) of the Banking Ordinance, no business of taking deposits shall be carried out in Hong Kong except by an AI. But the BI is not accepting deposits. It just receives some transfer deposits. It's a transfer. So this is not an offense for the BI to accept the transfer of deposits. So the legal protection to me seems inadequate. Well, to the customers, the $500,000 or $1 million of deposits is all they have got. So this is the bottom line, as the chairman has said. They are covered by, these customers are covered by DPS. And if the protection works in the first round but not in the second round, then it means that they are not protected by the DPS at all times. So I'm asking for more. Otherwise, the small depositors, the small customers may not be protected. Well, this is going to be very unlikely. But that's why I want you to do either of my proposals. You can just promise to do this in due course. And my proposals are in line with your legislative intent, so as to allayed our concerns. Can you consider doing this? Before you respond to the questions, let me stress one point.
At the start, Mr. To said that he could accept two arrangements. The transfer should not be the deposit should not be transferred to an institution which doesn't have a banking license, or you may amend the DPSO in the sense that there is a clear provision which covers the BI. I think according to the administration, it is in the first, in regard to the first arrangement. If you may refer to CB 1155, I don't know whether there is a difference in language. The MA as RA would not transfer a deposit-taking business to a BI unless it is an AI. So the English is would not. Now, Chairman, we have to be careful in dealing with the this ordinance, the FIRO. There is no provision that the MA would not or the RA would not transfer the deposit. So if you don't have this provision, then it can be interpreted as it has the power. I hope the administration can further explain this point. Thank you, Chairman, and Mr. To for the explanation. Well, we take your point. But as I said, it is not an administrative arrangement. Our understanding of the law is this. Basically, we would not and we could not transfer protected deposits to a BI which is not an AI and which cannot provide deposit protection. We can give the undertaking, if there is such a concern, we can give the undertaking that we will review the FIRO in the future. If there is a chance, of course there will be, at different stages, say of the amending company ordinance, we will look into that. We address the concern of Mr. To, we put it on record. We'll look at the FIRO as to how we can clarify the interpretation. I think that can assure Mr. To. We will not go down the second road, which is to amend the DPSO. We can give you the undertaking, Chairman. I hope the administration, in its second reading reply, no, there will be no second reading. How can you make this undertaking to the public? Maybe before the. In fact, we can give you a written reply to clarify this point. Can it be clearly, say, minuted? Maybe the secretary, the clerk can explain. I've lost my memory on this point. Now, these two pieces of subsidiary legislation, we extended the deadline to the 5th of July. Unless you have an amendment, after we've reported to the House, then the House will ask whether members would like to speak at the relevant LegCo meeting to move a motion of acknowledgement. And then during that motion, members can speak. And if there is such a request, then the administration will also reply. To play safe, I think it is good to have such an arrangement at a formal LegCo meeting. Maybe they can prepare a speech. We will report. I think the chairman will report the working of this subcommittee, and then raising our concern, and then the administration will read out their undertaking. I don't know whether Mr. Lau agrees. It will not affect the commencement date. If there is such a possibility, procedurally speaking, we'll do that. Chairman, to play safe, I suggest that you have two undertakings. The first, that you will formally, at the LegCo meeting, explain that you have no legal power, or rather you are not bound by the law not to transfer protected deposits to an institution which doesn't have a banking license under the BO. An AI is under the DPS. Now, this is the first point. Your understanding is that there is such a restriction in law. Can you repeat, Mr. To? Now, I've seen that you would not. My understanding is that this is just an administrative self-restraint. But if it is in the law, your understanding is that there is the legal restriction, that you cannot transfer a protected deposit to a non-AI. In the extreme, you don't have this power. This is the first point. Now, with this understanding, I know that administratively speaking, you are bound by this legal interpretation. And in view of members' concern, you will look into the file to see if there is any need for an amendment, if any, so as to put it down more clearly, your legal interpretation in the law, to avoid any doubt. Maybe I ask the HKMA colleague to explain. I think this is their work, and I try to make sure that that's accurate.
Sure. Thanks, James. So I think we can make that formal clarification, building on the letters that we've already, written responses that we've already provided, to make clear that the transfer is to a bridge bank. If we're transferring protected deposits, that we are required to ensure that it is that the BI is a bank, and we can set that out, I think, in writing. I think the other point.
Sorry to interrupt. Yeah. Well, my requirement of the government's pronouncement is that you understand, the government understand legally, that you will not have the power under this ordinance to transfer a protected deposit of a bank to a non-licensed AI, non-licensed bridging company, something like that.
You may say.
Yeah, I think that's right. I think if we're transferring protected deposits as part of
legally, you have no power under this ordinance to do that.
So it's an offence to transfer protected deposits to a non-authorised or a non-bank entity, and so that means that the bridge bank would be a bank and authorised to be a bank. I think the only point that I would draw your attention to is there are some other powers under the banking ordinance, so that pre-existed the FIRO, for the FS, the Financial Secretary, to sort of disapply some authorization requirements. So I think we mentioned this in our bilateral discussion. So these are pre-existed the FIRO. So under those powers in the BO, under Section 13, the FS can disapply some the authorization requirements. However, our understanding is that those powers have never been exercised. But just to be aware, under the banking ordinance, there are pre-existing flexibility for the FS to disapply some authorization requirements. But to reiterate, our policy intent under the resolution ordinance under FIRO is to ensure that the BI is a bank, and that we're required, if we transfer deposits, protected deposits, to the BI, to ensure that it is a bank.
Yeah, 主席。所以我哋頭先講。
Now, Chairman, we want to point out that instead of saying that we have no power to do such and such, we'll make a positive statement.
Deposits will be to a licensed bank covered under DPS. So that would be a categorical undertaking, making sure that when we do the transfer, it will not go into the third bucket like the concern of our member.
主席啊，我就係
Chairman, maybe you think your undertaking is very important. I think the legal understanding is more important than the administrative arrangement. if legally speaking you have no power, then you are bound by this interpretation. But whether you will, administratively speaking, whether you will do this or you will not do this is rather dangerous. If your understanding is that you have no power, you would not do that, then you can explain, you can pronounce your understanding or interpretation. I think, Mr. Lau, we all understand this point. Whether the whether Section 12(1) of the Banking Ordinance is interpreted, the RA in dealing with the transfer of deposit-taking business would the RA would not transfer a deposit-taking business to a BI, which is not an AI. Now, I was very careful in putting my words. Now, they would not transfer the deposit-taking business to the AI to a non-bank.
主席，我哋想嘗試解釋，即係用
Chairman, I've already explained. Now, the English is would not. We can change it to cannot. Cannot. Well, we have the law in English and also in Chinese. The law is very clear. 12(1) says very clearly. Chairman, let me be more specific. Can you say legally cannot?
No, we cannot.
I think that's the point we're trying to. We're saying we're trying to say it's a legal restriction.
Yes, we can. Yes, we can see that legally we cannot. Banking 12(1)(a Banking 12(1) does not allow this. Mr. To asks us, say we cannot. That's okay. We use would not is just in ordinary language. Say if we did this, then we have broken the law 12(1) of the BO. So we would not do it, and we cannot do it. Now, according to the law, we cannot do this. Whether you want us to use the word would not or cannot. Now you say you better say legally you cannot. I've already explained that 12(6) of the BO, receiving a deposit or taking deposit without authorization. Now you're dealing with this under the FIRO, and it's not taking deposits from the public, right? Mr. Lau, now you quote 12(6). You want to show from another perspective that if an institution without any authorization takes deposits, is in breach of the law. That is another angle. It is not an extension of your argument of 12(1). But that is not useful because the transfer of deposit is by another piece of legislation, not placing deposits or taking deposits from the public. Mr. To has repeated this maybe 3 times. When we say transfer under the FIRO, 1 out of the 5 partial property transfer. The transfer is not just pushing the deposits to the BI. When a bank is about to fail, when it becomes non-viable, then the RA and the bank in question will also will talk to the BI or the bank that will receive the transfer. That is taking deposits. Now there may be 10 million depositors. They will not negotiate with the bank. You must exercise your power, Mr. Wong. Well, I understand Mr. To's point. He's very careful, and that's a good attitude. Now, according to the administration, in terms of wording in English and Chinese, would not, cannot, or adding the description legally cannot.
I think this is in line with Mr. To's suggestion, and I think Mr. To should be satisfied. It's just a question of making a little bit of change in the way we put it. There's no need to continue with a debate like this. If the Bureau agrees that you would like to say that you cannot do this, then that's the solution. I think that there's no point to continue with this meeting. All right, I think Mr. Wong Ting Kwong has said, first of all, legally you cannot, or in law you cannot. So when this is discussed in a electrical meeting, you should say so, and I think that would be resolved. Well, yes, Chairman, as Mr. White has explained, we cannot just say that we legally cannot, because under the BO, Section 31, the FS has discretionary power. As we have set out in the paper, under Section 13(1) of the BO, the FS has the discretionary power to allow this, even if it's not a bank. But this pre-exists the current FIRO. But basically, that power has never been invoked. We understand Mr. To's concerns, so we are willing to change the wording, saying that we won't do this. We need to get our lawyers to prepare the proper version. We will say that we will not violate Section 12(1) of the BO. In that, we are not going to transfer protected deposits to a BI which does not offer the protection under the PTPS. And we are not going to exercise the discretionary power of the FS under Section 13(1). Well, that's exactly why I say you really can. You do have the power, and that's why you need to make a promise. That's just for the interim. I hope in the future you can introduce amendments to make sure that you actually cannot do this. Well, I know the FS has this power. Mr. Wong Ting Kwong. Obviously, the FS enjoys the power under Section 13(1) to deal with a bank which is about to fail, and he can transfer the deposits to a certain institution which may not be an AI, And now Mr. To wants you to get rid of this discretionary power. And the Bureau should consider the extent of the legislative intent under this ordinance. There is a question of trust. Do you trust the FS or the MA or the Bureau, FSTB? Would they exercise their power lightly or improperly? But I think we should be flexible in case of an emergency. If this is deleted, the FS will be deprived of certain administrative flexibility. I trust that they would not invoke the power improperly or lightly. I think Mr. Wong has put it very succinctly. We would discuss with our people after the meeting. We say that we're not going to ask the FS to exercise the power under Section 13(1). So first of all, we say we comply with Section 12(1), and that is it would be an AI. The BI would be an AI, and also the point of as made by Mr. James TO that transfer of deposit is not the same as taking of deposit. Well, this is not actually a problem. We can say we can put it explicitly that the transfer of deposit is actually taking of deposits, but this is not an issue to us. We don't think there's any problem with that. We would make sure that the transfer would be to an BI, which is an AI, and also we are not going to ask the FS to exercise the discretionary power under Section 13(1). All right. This is rather technical. I hope you can work out something within 1 or 2 days and give us something in writing, says the chairman. I don't care about Section 13(1). I want to protect the deposits. If I would be more assured if you deem the BI, which is as an AI, covered by the DPSO, then that would be even more assuring. But if up to a point that the FS would exercise his power not to protect the deposits, and you ask us to just trust you, then I'm not that assured. It depends on the wording used. If it's clear, and I believe that Mr. To's request will be met. So I'll give the administration some time so that at a future council meeting you can give a reply on the wording used. I've got some ideas myself on the wording to be used, and Mr. To may have his, Mr. Wong Ting Kong also may have his. Let's try to reach a consensus. Well, I always think about the worst scenario, and then I want to get the best wording we can. Do we have any deadlines as clerk to do this? 27th of June is the deadline. How many days? Next week is the next week. When can I withdraw this? I think you can do it in a very short time. I think it can be done any time. If they are ready by that time, then the President can just allow them to make a report. Or you need to report this to the House this Friday. Maybe I can make a suggestion. Today or tomorrow, I'll work out a draft and we can talk to Mr. To or Mr. Wong or the subcommittee. We'll have sufficient time, give you sufficient time to do this. There's no need to withdraw it first. We get some paper prepared. All right? Before Wednesday, please give us a written response to the subcommittee, and I will ask members if they are happy with it. The original plan is to report to the House this Friday, and then the Council meeting on the 5th of July will deal with it. So any other business from members? If I do it, then you don't have to do it. There will be a debate, and they will read out the things they have promised. So ask the clerk to do this on behalf of the subcommittee chairman. Any other business or business meetings adjourned? Thank you.